The Hon'ble Supreme Court has passed an essential order in the matter of Anantha Padmanabha Swamy temple administration in favour of travancore royal family. Meanwhile, ordered some guidelines for the sake of the best administration of the temple and protection of the wealth of Anantha Padmanabha Swamy. Many of you still carry the several questions pertaining to this, such as where are the roots of this case? Why the verdict of the Hon'ble High Court of Kerala's against to the travancore royal family? What is the main reason to open the Kallara A in 2011? I will try to answer all these questions in this video. This is what our today's point blank. Before going to the judgment, let us have a look at the roots of the case so that you will be able to understand the Hon'ble Supreme Court judgment comprehensively. The roots of the case are in 2009. In 2009, T.P. Sundararajan, a former IPS officer and also a lawyer, filed a public interest litigation before the Kerala High Court. In that petition, he prayed the Honorable Kerala High Court to create a transparency in the Padmanabha Swamy temple administration, and also prayed that the control of the temple should be handed over to the Kerala government from the Travancore royal family. At that initial moment, the state government of Kerala took a stand before the High Court that the traditional and customary belief is that the temple belongs to the royal family head of the Travancore palace, and that the administration of the temple has not broken down, nor is there any allegation of the major nature which forces the government to interfere with the administrative affairs of the temple. Despite that, the High Court, by its judgment rendered in January 2011, ordered the state government to take over the control of the temple. The Honorable Court also restrained the executive officer and the Maharaja of the royal family against opening any of the Kallaras or removing any of the articles of the temple. The dispute lies in the agreement of the accession signed between the kings of the Travancore with the government of India in 1949, by which the princely state of Travancore became a part of the Indian Union. The Article 7 of the agreement provides that administration of the Padmanabha Swamy temple shall be conducted subject to the control and supervision of the ruler of Travancore by an executive officer appointed by the ruler. The ruler at the time of independence, Chitra Tirunal Balarama Verma, passed away in 1991, and the Uttradam Tirunal Martanda Verma assumed charge as a trustee of the temple. The question before the High Court was whether the new Maharaja would fall within the definition of the term ruler used in the agreement. The agreement itself did not define the term ruler, and the High Court therefore relied upon the definition of ruler in Article 366 Clause 22 of the Constitution of India. This article states that ruler means any prince or chief who was recognized by the President of India as ruler of an Indian state before 1971, the year in which the privy purse was abolished. What is a privy purse? India map was not in the shape at the time of independence like what we are seeing now. It contained several kingdoms which were administered by kings as their wish. These all kingdoms were brought down of one umbrella, that is Union of India. Mr. Sardar Vallabhbhai Patel played a great role in formation of Union of India. The payments made by the government of India to the royal families of erstwhile prince states for the joining the Indian Union at the time of independence is called privy purse. In depth of the privy purse, I will make a special video on this. Based on the definition in Article 366 Clause 22, the High Court held that ruler is not a status that can be achieved through a succession. And after the death of the last ruler in 1991, there is no ruler in the erstwhile state of Travancore. In such a scenario, the present ruler is the state of Kerala, and the administration and the control of the temple will therefore vest with the Kerala government. The High Court had passed its verdict. As per this verdict, the administration powers were completely given to the state government of Kerala. Aggrieved by this order, immediately the Maharaja Uttradam Tirunal Martanda Verma appealed to the Supreme Court against the High Court verdict. The Honorable Supreme Court had stayed the High Court verdict. Meanwhile, Supreme Court ordered a detailed inventory of the articles at the temple. For that, it appointed a committee to open the Kallara A on 13th June 2011. T.P. Sundararajan, who filed the case in High Court of Kerala in 2009 against the Travancore royal family, was also one of the members of the 6 members committee. Even before to the committee's formation, out of 6 Kallaras, A, B, C, D, E, F, 4 Kallaras, that is C, D, E, F are under custody of the temple priests. They used to open the C, D, E, F Kallaras 8 times for every year. These Kallaras are opened on the occasions of the temple festivals. The ornaments of the Padmanabha Swamy are used and deposited back after the celebrations. But the mystery is lying in the two Kallaras, that is A and B, as they were not opened from hundreds of years. On 27 June 2011, the committee opened the Kallara A by unlocking iron grill and heavy wooden door. Then removed a granite slab from the floor beneath. A few steps led to the dark room which stores the treasure. The various items found scattered everywhere were not arranged systematically. There were baskets, earthen pots, copper pots, all contained valuable objects approx worth 1 lakh crore. The discovery of the treasure attracted the widespread nation and international media attention, as it is considered to be the largest collection of the treasure. This brought the world's richest temple identity to the Padmanabha Swamy temple even before the opening the Kallara B. The Kallara B was not opened due to a stay order was taken by the Travancore royal family from the Hon'ble Supreme Court of India. The ex-Travancore rulers had been saying that the opening the last Kallara could invite the wrath of God. In August 2012, senior advocate Gopala Subramaniam was appointed as amicus curiae by the Supreme Court of India to inquire into the temple trust administration and safety of the wealth. The temple was controlled by a trust headed by the Travancore royal family until April 2014. Because the amicus curiae submitted a voluminous report before the court in April 2014 alleging serious mismanagement of the temple by the trust and indicating the royal families on various counts. The court, after accepting the report, arranged a 4-member administrative committee on April 24, 2014 headed by a district judge to manage the temple. Also ordered a special audit of the temple and its properties by former Controller and Auditor General of India Vinod Rai. When the Supreme Court by interim order directed its management to be taken care of by a 4-member administrative committee. This committee managed the affairs of Anantha Padmanabha Swamy temple till the present judgment of the Hon'ble Supreme Court of India. How the Hon'ble Supreme Court order is a game changer. What are the major developments suggested by the Hon'ble Supreme Court in respect of the temple administration? How judgment provides a great safety to the wealth of the world's richest God. We will discuss about the final judgment of Hon'ble Supreme Court of India in next part. Subscribe my channel to get the part 2 notification into your mobile. I will be back with that interesting part again. Till then, this is Vidyasagar signing off.